Welcome to Planning for Protection.
Welcome back to Planning for Protection with attorney Jeff Ryder. Jeff is an elder law and estate planning attorney serving families and aging adults across Carroll County and the surrounding Indiana communities. I'm Evan Mack, and today we're talking about estate planning considerations for a spouse when the other spouse has entered a nursing home, including whether and when updating a will may make sense. Jeff, welcome back, sir.
Hello, Evan. Thank you. It's nice to be back.
Awesome. Jeff, when a spouse enters a nursing home, what usually changes legally for the spouse who remains at home, and why does that issue come up at that point?
Well, that's a very good question. Many people have what we would call a fairly straightforward and simple will. Everything to my spouse, and if my spouse predeceases me, everything to our kids in equal shares. That's a very common will. And so if your spouse enters a nursing home and you've got that standard will and you unexpectedly die before the nursing home spouse dies, suddenly your will says everything goes to that spouse in the nursing home. And if they happen to be on Medicaid or want to apply for Medicaid, those assets that would go to that spouse will very likely disqualify them from receiving Medicaid benefits. So what can be done? Well, that's what we're going to talk about today.
So yeah, Jeff, so when one spouse enters a nursing home, what assumptions do families tend to make about whether the at-home spouse needs to change their will?
Well, if you're not working with an elder law attorney, you may not even think about that. You may not consider it. And so we try to always remind people, if we're working with a couple or a single person on a Medicaid application, especially if they have a spouse, we always recommend that the spouse change their will. And the reason for that is, as I just touched upon, if you leave everything to the spouse in the nursing home, it will, very likely create an issue with their Medicaid eligibility. So some people think, oh, well, I know what I'll do. I'll just change my will and we'll leave everything to the kids and bypass the spouse. And that seems to make a lot of sense. But Indiana says not so fast. We're not going to allow that to happen. We're going to have a public policy that says you cannot disinherit your spouse. And if you do, the state of Indiana Medicaid office has a right to elect against your will that attempts to disinherit your spouse. And it's state policy. We're going to require you leave at least 50% of your estate to your surviving spouse. And the state can elect against the will to force that result. So there's ways around that, and that's why the spouse at home might want to update their will.
So, Jeff, how can an outdated will create those problems with long-term care planning or maybe asset protection for the spouse who is still living independently?
Yeah, well, if that community spouse is willing, and we recommend they do, they could create a will which does leave 50% of their estate, at least 50%, sometimes all of it or more, a bigger percentage, to their institutionalized spouse. But we do it in the form of a supplemental needs trust within the will. And Indiana right now recognizes that is a substantially equivalent arrangement to 50% outright to the institutionalized spouse. And we make the children, or a bank if they don't have trustworthy children, the trustee of that supplemental needs trust. And then the trust is designed to supplement, but not replace, the Medicaid benefit that they might be receiving for their primary cost of their nursing home stay. And that supplemental needs might be things that enhance their quality of life, perhaps a better cable package, perhaps a better cell phone plan, perhaps more candy or whatever, makes more enjoyment to the institutionalized spouse. But oftentimes there are substantial assets left in the supplemental needs trust at the death of the nursing home resident, and we make the children typically the residuary beneficiaries of that supplemental needs trust. So it is available during the lifetime of the institutional spouse, but upon death, it passes to this residual beneficiaries, the children.
Mm. In Indiana, what happens if the at-home spouse will leaves assets directly to the nursing home spouse without considering Medicaid eligibility or future care needs, Jeff?
Well, as we've just been discussing, the state would prefer, of course, you just spend all your assets at the nursing home and have
Okay.
nothing left for the family. But
Mhm.
through the use of the supplemental needs trust, you can the will would typically say 50% to the children and 50% into a trust for the benefit of my institutionalized spouse. And then when that institutionalized spouse passes, what's left in the trust, which is oftentimes a high percentage of the assets, can be distributed to the children. So it's a way to follow the Indiana law and avoid the election against the will that might otherwise occur if you try to bypass completely the spouse and yet still protect the assets for the benefit of the family.
Mm. How do beneficiary designations and jointly owned property factor into a decision, especially if the will hasn't been updated in many years, Jeff?
Well, you know, beneficiary designations are a great and relatively inexpensive and painless way to try and avoid probate. And that's always a goal that makes sense for most people. But unfortunately, those designations do not protect very effectually from the potential for estate recovery. And even if a person is a POD or TOD beneficiary, say of a bank account or a stock or bond, the state of Indiana has the ability to open an estate and file a claim and then request permission from the court to pursue non probate transfers like these beneficiary designations. And the state is not uh, especially adept at that right now, but I feel like as time goes by, they will get more and more adept. And so I can't recommend that people consider a beneficiary designation as a sufficient and necessarily totally effectual way to try to protect assets. It doesn't do that. It does avoid probate, but it does not offer protection from the potential for estate recovery. Because when a Medicaid recipient passes away in Indiana, the state, by law, has a priority claim against their estate to be reimbursed for any funds that they've spent on that person's care in the nursing home. And that priority claim is, of course, comes ahead of many other creditors and definitely ahead of residuary beneficiaries, which are usually the children. So you want to avoid those claims if at all possible.
Mm. From a planning standpoint, when does updating a will actually make sense after one spouse enters that nursing home? And what should that update be trying to accomplish, Jeff?
Normally, we try to do it during the process of applying for Medicaid. We do it, usually actually while we're in the process of applying or very soon after, because you never know, and you could be hit by a car driving home, and so it's always good to get it done and be ready for whatever eventuality might occur.
Hmm. Are there tax or probate considerations the at home spouse should be thinking about when deciding whether to revise their will at this stage?
Well, there's always tax and probate considerations to be done, and so if you've got an asset protection trust, say, then the assets that you would need to worry about putting into and passing under the will through a supplemental needs trust would be limited and not perhaps not very significant. If you have the option, it's always generally a good idea to avoid probate, and it's a good idea to try to protect in many ways as you can the assets that you worked all your life for and maybe done without and struggled to accomplish and accumulate what you have accumulated.
Hmm. Can you share an example of a situation where a spouse didn't update their will after the other one entered the nursing home and it led to avoidable complications later on?
Well, I can think of a situation. A lady had a maybe a about a 60-acre farm in Carroll County, and she ended up going to the nursing home. And I had not worked with her until they actually came in to get assistance with the Medicaid application. So it wasn't possible to do any protection strategies for the farm because any transfers at that time would have created a 5-year period of ineligibility for this woman to be able to get Medicaid. And she needed Medicaid right away because while she had this 60 acres, she didn't have much else in the way of assets. And so I advised the family, we're going to be facing a potential claim by the state of Indiana for reimbursement when she passes. And she lived a few years, and the state did end up paying significant amount of money for her care. And of course, they in this particular situation, they did open an estate for her and file a claim. At which point, we uh, sprang into action and uh, began to negotiate with the state of Indiana to try to get a settlement whereby if the family could come up with some cash, then they could get a discounted value from the for the settlement with the state. And we worked with a friendly local banker, and he was able to make a short-term loan that was able to generate cash, and we got the state claim settled, and then the family sold the farm after she passed. So it worked out well. But if you have the option not to even worry about the claim to begin with, it's always better to do that. But
Hmm.
if you do end up with a claim, it's not the total end of the world because number one, the state of Indiana gets a discount on the what would ordinarily be the private pay rate at the nursing home. So if the private pay people are paying 10,000, the state may pay 8,000 a month. Number two, those payments do not accrue interest. So essentially, you're getting an interest-free loan from the state of Indiana at the discounted rate. And the third option, of course, is the ability to negotiate to try to get a settlement if there is a claim after death.
Hmm. And Jeff, for a spouse listening right now whose husband or wife is already in a nursing home, what signs should prompt them to sit down with an elder law attorney to review their overall plan?
Well, that's a very good question, Evan. Occasionally, I get a client come in and say, mom or dad has been in the nursing home for 3 years, and the money is dwindling fast. There's not much left. Can you help us apply for Medicaid? And my first thought is, boy, I wish you would have come and seen me when they first went into the nursing home. We could have had so many more options and done so much more. But, it is what it is. You can never go back and, erase what's happened. You've got to move forward. So at that point, we give them the best plan that's possible based on the timing for what they've got left and what the situation is at that time. But it's definitely the first call you should make is to your elder law attorney if your spouse is looking at potentially a long-term care stay. And even if they're in the hospital and they're looking like they're going to have to go to a nursing home for rehabilitation or therapy, it's probably worth making an appointment to get at least know what your options are. And I I view myself as helping to set a smorgasbord table. There's so many options, and there's so many things you can do, and not every one is right for every family. And so every family is unique. Every family's got different goals, different assets, different healthcare projections, different cost needs. And so we try to tailor it to fit, that particular family's situation and what their preferences and wishes are. And there's a lot of things we can do, and I highly recommend people reach out to an elder law attorney to be able to find out what their options are and what can be done to uh, mitigate the out-of-pocket costs they're going to end up spending at that nursing home.
Amazing. Jeff, thank you for your time.
You're welcome, Evan. Thank you.
All right. That's it for today's episode of Planning for Protection. If you'd like to learn more about attorney Jeffrey Ryder, visit jryderlaw.com. Thanks for listening, and don't forget to like, subscribe, and leave a review if you found this episode helpful. Thank you so much, and we'll see you next time.
Thank you, Evan. Have a good day. Bye-bye.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.